Nobody tells you when the system quietly shifts gears. There is no press release. There is no official email to your inbox. One day, the process is moving at one speed, and then gradually, without announcement, it starts moving at another. And the people who were not paying attention, the ones who assumed everything would stay exactly as it was when they first filed, those are the ones who get caught off guard at the worst possible moment. What is happening right now inside the family visa system is exactly that kind of shift. And if you have a petition pending, a priority date you are watching, a spouse or parent or sibling waiting overseas, or a case somewhere inside that long administrative pipeline, then what you are about to hear matters directly to your situation. If you find this kind of analysis useful, subscribe right now and hit the like button. There are people waiting on this content who need it, and your support makes sure it reaches them. Let us get into it. For years, the family visa system operated in a particular rhythm: long waits, slow movement, priority dates that crept forward by days rather than months. Applicants learned to wait passively. They filed, they waited, they checked the visa bulletin, they waited some more. That rhythm created a particular mindset. The mindset that nothing will happen fast, so there is no urgency to stay current, stay organized, or stay engaged with how the system is evolving around them. That mindset is now working against people because the system has started to move differently. Processing volumes at the National Visa Center are shifting. Interview scheduling at certain consulates is accelerating in specific visa categories. USCIS domestic adjustment timelines are compressing in ways that are showing up in case data. And here is the critical part: when the system speeds up, it does not slow down to accommodate applicants who are not ready. It moves through them, flags what is incomplete, and continues. The people who get left behind in an accelerating system are not the people with bad cases. They are the people with good cases that are not properly organized. So let us talk about how this system actually works behind the scenes, because most applicants only see the surface of a process that has significant depth underneath it. Your family visa case does not live in one place. It moves across multiple agencies, each with its own database, its own processing standard, and its own communication timeline. The National Visa Center holds your case during the document collection phase. USCIS adjudicates the underlying petition. The Department of State controls what happens at the consulate. These systems share information, but not seamlessly and not instantly. A change in evidentiary standards at one agency takes weeks or months to become visible at the next stage. By the time an applicant sees the effect of a policy shift in their own case, that shift has already been in place for a while. This is the gap that catches people, not the dramatic moments, the quiet institutional lag between when a standard changes and when an applicant realizes the standard has changed. There is also the database dimension that most applicants never think about until it becomes relevant to them personally. Every case generates records across multiple federal systems simultaneously: DHS databases, State Department consular records, FBI background infrastructure, financial verification systems. When these records are clean, consistent, and current, they move through the system without friction. When they carry inconsistencies, even minor ones, the case routes differently. It may trigger an additional review layer. It may generate a request for evidence that looks routine but is actually a flag response. It may produce an interview that feels procedurally heavier than expected because the officer is working from a complicated record rather than a straightforward one. Most applicants in that situation assume the system is just slow. They wait. They do not realize that the delay has a specific origin that could have been addressed if they had known to look for it. Now, here is where it gets specific, because when processing standards tighten, not everyone gets equal scrutiny. The system concentrates attention on particular profiles first, and understanding those profiles is how you assess your own exposure honestly. The first profile is anyone with a documentation gap in their timeline. This is not about fraud. This is about any period where your status, your address, your employment, or your travel history is not cleanly and consistently documented across your record. A gap between one status and another. An address that appears differently across different filings. A travel record that does not align precisely with what the database shows. These gaps did not always generate problems. In an accelerating tightening system, they begin generating requests for explanation. The second profile is applicants managing multiple simultaneous moving pieces, a pending renewal while a petition is also in process, a change in the petitioner's circumstances that has not been formally documented, an employment shift for the sponsor that affects the financial affidavit on file. The more elements in motion at the same time, the more surface area exists for inconsistency. Officers adjudicating these cases must reconcile a more complex picture. Complexity, when it is unexplained, creates friction. The third profile is applicants who have been passively waiting without maintaining their case. Address changes not reported sponsor financial situations that shifted significantly without updated documentation. Petitioner status changes that were never formally communicated to the relevant agency. These are the cases where acceleration in the system creates the most abrupt disruption, because everything that should have been addressed incrementally over time now surfaces simultaneously at a critical processing stage. Here is where exposure increases in ways that feel procedurally ordinary but carry real weight. Airport entry screening is one of the earliest places where a tightening administrative posture becomes tangible for applicants. Travelers with pending family petitions or those traveling on documents approaching expiration may encounter more detailed questioning. The officer at the port of entry is working from database information you may not have reviewed recently. The questioning itself is not the risk. The inconsistency between what you say and what the record shows is the risk. Knowing your own record before you travel is not optional preparation, it is basic protection. USCIS interviews are another place where the shift becomes detectable. Internal guidance for officers is updated regularly, and it does not get published in a way that applicants can easily track. When that guidance tightens around a particular category, interviews become more specific, document review becomes more granular, and requests for additional evidence become more frequent. Applicants who arrive organized move through this environment with relative ease. Applicants who are encountering their own file for the first time at the interview table face a very different experience. Now let us address what is not happening, because this is where community rumor and administrative reality diverge in ways that create unnecessary fear. Family-based immigration has not been suspended. Priority dates continue to move. Interviews continue to be scheduled. Cases continue to be approved. What is changing is the standard of review and the speed of processing, not the existence of the pathway. The applicants most affected by tightening standards are those whose cases carry unresolved complexity, not those whose cases are clean, current, and well documented. That distinction matters enormously, because if your case is in good order, acceleration in the system works in your favor. Cases move faster. Priority dates become current sooner. Interviews get scheduled more quickly. The same system that creates friction for disorganized cases creates opportunity for organized ones. So let us talk about what preparation actually looks like right now. Start with a complete, honest review of your own case file, not what you believe is in the file, what is actually in the file, every document submitted, every address reported, every employment record used, every travel entry in your history. Inconsistencies identified during your own review can be addressed proactively through supplemental documentation or legal guidance. Inconsistencies identified by an officer during an interview are significantly harder to manage under pressure in the moment. Legal consultation timing is something most applicants get wrong. They wait for a problem to appear before consulting an attorney. The more effective approach is to consult before a critical stage transition, before an interview is scheduled, before a request for evidence arrives, before a renewal deadline is close. An attorney reviewing a file in advance of a stage transition can identify vulnerabilities that the applicant genuinely cannot see from inside the process. Travel decisions deserve serious thought if any element of your immigration status is currently in transition. Not every trip creates risk, but traveling while a petition is pending, while a status is in a renewal window, or while a case is approaching a critical stage introduces variables that are unnecessary and avoidable with proper planning. Document organization is the foundation of everything. A complete chronologically organized record of your immigration history, your sponsor documentation, your financial evidence, and all agency correspondence is what allows you to respond quickly when the system moves. And right now, the system is moving. If you have a specific situation you want to walk through, describe it in the comments below. Comments are reviewed and responses are provided where possible. And as always, everything shared here is general informational analysis. It is not legal advice. For guidance specific to your circumstances, work with a qualified immigration attorney. The system is accelerating. The people positioned to benefit from that acceleration are the ones who are ready for it. Make sure you are one of them.